What's up, everyone out there in YouTube world, Facebook world, social media world, the world, wherever you're watching this from today. Welcome to another quick episode of Musings with MGL. I'm your host, as always, MGL. As always, like, share, subscribe, hit the bell notification, ding, ding, ding. I'd really appreciate it. Today, we're going to do a quick little rundown of a topic that I get a lot of questions on. A lot of people hire me to help them with this issue, and that is, how do you restore your firearm rights in the state of Florida? Okay, this is only for the state of Florida. Once again, I am a gun lawyer who operates in the state of Florida, so any other state besides Florida, I can't help you out. Every state is going to have their own rules for how to restore your firearm rights. So I'll start with a global concept. If your firearm rights were taken away for felony convictions. So if you're convicted of a felony in any state in the United States of America or by the federal government, you are a prohibited person and cannot possess a firearm. You can't buy one. You can't possess one. It's illegal. It's going to be illegal on the state level, and it's going to be illegal on the federal level. So once your firearm rights are taken away, they're taken away by the state that took them away, or if it was the federal government took them away. However, there are ways to restore your firearm rights once they are taken away by your state or the federal government. Now, if your rights are taken away by the federal government, let's say you get convicted of a federal crime, there is no way to restore your rights. There is no system in the federal government to allow for somebody to restore their firearm rights if they're taken away by a federal conviction. The only thing you can do is get a pardon or clemency from the president. That's it. So unless you know somebody who golfs with the president on the weekend or whatever and can get you a pardon or a clemency, there's nothing you can do about it. You have a federal conviction, you're out of luck. There's nothing you can do. If you have a state conviction, so if you were convicted of a felony or a misdemeanor domestic violence charge, which is one of the other ones, your firearm rights are going to be taken away. That state will have a mechanism to restore those rights, and you have to get your rights restored in that state. So you cannot, if you're in, let's say, Texas, and you get a felony conviction in Texas, and you move to Florida, nobody in Florida can restore your rights. As a Florida attorney, I cannot restore your rights. The state of Florida cannot restore your rights. Only the state of Texas would be able to restore your rights. So whichever state took your right away is the only state that can restore it. Every state has their own mechanism. So wherever you got your felony from, you need to figure out where that state, what state that is, and then what their process is for restoring your rights. This is the process in the state of Florida. So if you have your gun rights taken away in the state of Florida because you were convicted of a felony or a misdemeanor domestic violence in the state of Florida, we do have a process for restoring your firearm rights, okay? It is done through the Office of the Executive Clemency. I've pulled up the application of here on the video. So everything starts with the application. Now, there are a couple qualifiers that you need to know before you can do the application. One of them is what I just went over, which is it a Florida conviction? The second one is you have to be 8 years removed from the completion of your sentence. So not from the conviction of your sentence, not from your arrest date, 8 years from the completion of your sentence, whether that's prison, probation, community control, whatever it is. And that includes everything from your sentence, including fines and fees. So if you have served time in prison and or finished your probation completely, but you owe $50 to the clerk's office for some sort of fee, you can't fill out your application until you've paid that fee. So you have to be 8 years from the completion of your sentence. The fees aren't included in that, by the way. So let me make a distinction. So when you get off probation or supervision, you have to wait 8 years. If you still owe $50 and you get to the 8 years and you fill out your application, you'll be able to go pay that $50 and it doesn't start the 8 years all over again. But you can't fill out the application until at least all your fees are paid, and it has to be 8 years from the completion of your supervision. Let's put it that way. So you got to wait until you're done with probation. Let's take an easy example. You're on probation. You get off probation. You've paid all your fees. 8 years from the date you get off probation, you can fill out this application for executive clemency. It's on the website. You just go to the Florida, just type in Florida Office of Executive Clemency or Florida Application to Restore Firearm Rights, and it'll take you right to the government website where you can find this application. When you look at it, you can see there's a bunch of different things you can ask for. Top one is a full pardon, includes firearm authority plus restoration of civil rights. Eligible to apply 10 years after completion. pardon without firearm authorities. So if you just want a straight up pardon, 10 years after completion of your sentence. This is the main one we're going to be talking about here, which is the third one, which is specific authority to own, possess, or use firearms. So firearms authority only. Eligible to apply 8 years after completion of the terms of your sentence. So this is the one we're going to use. There's the next one is just the restoration of your civil rights. So you see right to serve on a jury, hold public office, and vote. That's basically, you get that automatically from the completion of your sentence. It used to be you had to wait and jump through all the hoops. We passed a constitutional amendment down here a couple years ago that basically says once your sentence is over, you get all the rights back automatically. So that's easily. That's pretty easy. So the main one we're talking about is specific authority to own, possess, or use firearms. So the first thing is you got to fill out this application. It's pretty simple and self-explanatory. This part here is just biographical, name, current address, date of birth, phone number, email address, etc., etc., etc. So obviously you would fill this out on your own. For right now, it still says sex, male and female. The state of Florida is probably going to leave it that way, but I imagine if you looked at one of these in California, it might have about 50 different boxes on it. But that's a discussion for another video. So you fill out your biographical stuff. Down here is where your charges and stuff go, okay? So you need to find out where your charges are, and then you need to list them here. So let's use something easy. Let's say you were convicted of possession of cocaine in Miami-Dade County. You just put that here. Possession of cocaine, Miami-Dade County, date, all those kind of things. If you don't know, you can go to the clerk's office and look up your name. Most clerk's offices in Florida have public access. Well, they all have public access by statute, and you should be able to go on there and look and find your case number and all your documents and everything in there. If not, you can also go to the FDLE website. That's Florida Department of Law Enforcement. You can go to their website, and they have a button that says, I want to do a background check on myself. You can pay them $25, put in all your information, they'll send you a background check in an email. It takes about 5 minutes. You'll get an email with your criminal history on it. And then you'll be able to go through that, and you'll be able to list, it's like a credit report basically. It lists all your charges, what counties they were in, dates, and everything out. So you fill that situation out. Then you got to get documents. So you see here where it says court documents section. So then you would go to the clerk's office, and you would get certified copies of the documents that relate to your case. So your charging document, it's called an information in Florida, your judgment and sentence, the termination of probation, the termination of supervision. There's a list of a few things in here. You see right here, number 1, certified copy of the charging instrument, indictment information or warrant. 2, judgment and sentence that may include an order of community control and or order of probation. And so you fill that out. You got to gather those documents. So you can go to any clerk's office in Florida and have certified copies of those documents. They'll print them out for you. You can order them online. They'll mail them to you. They usually charge a fee for certified copies, $5 or $10 or something like that. And then you got to gather up certified copies of those documents. Then you take all of those documents along with this application and you mail it in to the Department of Clemency address. It tells you right here on the form where to send it. And so you send that in, and that's your initial paperwork. At that point, the Clemency Department will get all your documents, and they'll go through all your documents. If there's something missing, let's say you're missing a court document or something like that, or you do owe fees or whatever, they'll send you a letter that says, this is what we're missing, go get it and send it to us, or you owe this money, go pay it, and then send us receipt. At some point, they'll either have everything correct in the initial paperwork, or if you got to go gather stuff and supplement it. But either way, at some point, they'll have all the documentation that they need. So they will then send you a letter that says, congratulations, we've received all the documentation that you need or that you sent in, and you're ready for the next step. So what's the next step? The next step is an interview with the Clemency Board. So you will be interviewed by somebody who works for the Clemency Board about your request for clemency. It's something that you might imagine if you see on TV, like somebody goes in front of a parole board. They're asking you questions like, hey, why do you want your gun rights back? Have you lived your life well since then? Where are you now working? What was different about your life then that's your life now? Why should we think that you can have a firearm? So you have this little question and answer hearing with this person. You're allowed to bring character witnesses. You're allowed to get character references, letters that people write, and bring them to these hearings and present all of this stuff to the clemency officer. The clemency officer will then go through all your paperwork and decide whether they think you should qualify to have your clemency restored. Then they will send your paperwork to the governor, and you get put on the list of everybody else who wants to have their clemency rights restored, and then the governor just signs a thing almost like mass pardons, and then you get a little thing in the mail that says, hey, congratulations, you got your rights restored. So the good news is Florida has a process for sending that in. Now, here's some of the bad news. The bad news is that the time between them getting your application and sending you that letter that says, congratulations, we've got all your stuff, you're ready for the next step, and then the next step being that interview, the time between getting that paper, that letter, and the interview is about a decade. That's right, I didn't misspeak. It's about 10 to 12 years of backlog of these applications because they are understaffed and they are underfunded, and there are thousands of applications that they get probably a month or a year on these, and they are just backlogged to the hilt. So when you gather up all your paperwork and send it in, that can be done in 2 or 3 weeks, and then you get that nice little letter. Then you're going to wait about 10 to 12 years to get your hearing. Then it could be another year or two wait before it gets to the governor's desk, and then the governor may not sign it. They may sign it. Who knows? And so it's not a guarantee that you'll get your rights restored, and it's not a fast process. If you have everything done correctly and you give a good interview, there's no reason you probably shouldn't get your rights restored. But the problem is it's a long wait. So people need to decide individually, is it worth the wait or not? There is no other process. Again, you can go for a straight pardon or something. And again, if somebody plays golf with the governor on the weekends, maybe you can get a quick pardon or an executive clemency straight from the governor without having to go through this process. But if you want to restore your firearm rights in the state of Florida, there is no other process to do it. There's no motion you can file in front of a judge to overturn your ruling or withdraw your plea or change your sentence or anything along those lines. Once you're convicted, it's on your record forever, and the only way to get your firearm rights restored is to go through this process. It's a fairly easy process, but unfortunately, it's a time-consuming and lengthy one. Now, the question is, do you need an attorney for this process? Well, no, you don't need an attorney for any process. You can represent yourself in a murder trial or a divorce case if you want to, so you don't need an attorney. It's not required. You can do it on your own. However, having an attorney can be beneficial because they can make sure all the T's are crossed and the I's are dotted, because you don't want to drag out. I mean, you got to wait 10 years anyway, and if you keep screwing your paperwork up in the beginning, it's just going to keep making things longer, because you're going to have to keep resubmitting paperwork or gathering things or whatever. So what a good lawyer can do for you is make sure your application is filled out correctly. They know how to get the documents from the clerk's office. They can put them together. They can make sure they all get sent to the right place. They can monitor you getting the letter, and then assuming that the attorney doesn't die in the next 10 years or 15 years or retire or something, then that attorney is allowed to go with you to that meeting with the clemency board where they ask you questions. The attorney can gather the witnesses and gather the affidavits and things like that and present all of that to the judge or the hearing officer in a cohesive way to make sure that your hearing goes smoothly and that all your paperwork is correct. So there is a huge benefit, like anything else, to having a lawyer, but it's not required. But that's essentially it in a nutshell, ladies and gentlemen. That is the process. Unfortunately, again, it's an easy one, but it's not a speedy one. You're stuck in the government bureaucracy of how this works. And as you can imagine, there's always a possibility that somebody can change the law and create a better system or increase funding so they have more people to review these. But as you can imagine, if you're a politician, running on a platform of restoring firearm rights to convicted felons probably isn't going to get you a lot of votes. A lot of people out there, even in the gun community, are going to say, well, yeah, screw those people. They got a felony, and so I don't care if they ever get their gun rights back. The problem with that is there's a lot of people who have old felony convictions from like the 70s for marijuana or something when they were 18, and now they're older, they're wiser, and they want to have their gun rights back, and they can't have them. There are a lot of crimes out there that can make you a felony or felon that aren't bad crimes, or they're stupid crimes. Again, small drug possession or marijuana over 20 grams, writing a bad check for more than a certain amount, driving while license suspended. You can get a couple of those on your record, then you end up with a felony. Criminal mischief is something that's based on the value of the item. So if you go key somebody's piece of crap old car from the 80s, it may be $200 and you're going to get a misdemeanor. But if you key somebody's Lexus, it may be $1,000 to repaint their door, and now you're looking at a felony when it's the same action. That doesn't mean you should be going around and keying people, but if you key somebody's car, when you're 20 years old and get a conviction, and now you're 40 or 50 and you want to have a gun, you should be able to have a gun at that particular point. So whether you agree with it or not, this is the process. It's the only one that currently exists. If you would like the help of an attorney, obviously just Google attorneys in your area that handle Second Amendment situations and restorations, and you can hire one or you can try and figure it out yourself. But that's it in a nutshell, ladies and gentlemen. Thankfully, we do have a process in the state of Florida for doing it. Unfortunately, it's not a speedy or very efficient one, but it's the only one that exists. So if you're young or middle-aged and you got plenty of time, you might as well get the clock starting. There's some people that call me and they're like in their late 70s and they're thinking, well, what's the point? Because why would I pay you if I got to wait 10 years? I'll be dead by then. So they end up not doing it. So it's a personal decision that everybody has to make regarding what they want to do. But that's it. If you have any questions, if you'd like to comment down below, please do so. Like, subscribe, share, click the bell notification. And thanks for watching. So I'm going to end it here. So as always, stay safe, stay healthy, stay vigilant, and as always, carry on.